Hello students, my name is Advocate Bhushan Bhoir from CKT College, Accounting and Finance Department. Today we are going to learn the types of contract from business law. So as we know the definition of the contract means any agreement which is enforceable by law, it's called a contract. So for the types of contract, there are main four types of contract: on the basis of formation, on the basis of nature of consideration, on the basis of execution, and on the basis of validity. So on the basis of formation, there will be express contract, implied contract, and quasi contract. On the basis of nature of consideration, that is bilateral contract and unilateral contract. On the basis of execution, that is executed contract and executory contract. And on the basis of validity, there will be valid contract, voidable contract, and illegal contract, which is more used in business law. So on the basis of validity, the six types of contract are valid contract, void agreements, enforceable contract, voidable contract, and illegal contract. So as the first, we will see the valid contract. Any contract that fulfills the provision under section 10 of the Indian Contract Act 1872 is called a valid contract. Just like when we make a transaction with a shopkeeper, we go to the shop and purchase certain things, and by giving them a certain amount, a particular amount of that product. So that contract will be called as a void contract because all the main conditions are fulfilled in that transaction. As we know, we are getting something, and for that something we are exchanging, or we are giving the shopkeeper something by money or money's worth amount. For example, if we purchase a notebook from the shopkeeper and buy that notebook, for that notebook we will give 20 rupees or 50 rupees, the price of that notebook. So this contract between me and the shopkeeper is called a valid contract. Then second one is a example: a offer to sell his house for a 5 lakh to B, and B agrees to buy it for this price. It is called a valid contract. Second one is a void agreement or contract. An agreement which is not enforceable by law is said to be void. A void agreement has no legal consequences, just like agreements or contract with a minor. If any minor or below 18 person make a contract with any person, that agreement is called void agreement, or that contract is void ab initio. Matlab, from beginning the contract will be have no legal consequences in future. So minor agreement: an agreement which has legally enforceable when entered into, but which has become void due to supervening impossibility of the performance. Just like a war between India and China, or war between India and Pakistan. So if there is a trade or contract between India and Pakistan for a particular product, and now this current situation or the war situation, that contract becomes a void, because when two countries are in war with each other, the contract held between them is termed as a void contract. So as per the pictures, you can see the obligation and rights within a contract, duties, rights, and obligation agreements between two parties, that is India and China, are void. For example, again void contract: a void contract between a citizen of China and India is valid contract during the peace, but if war breaks out between these two countries, the agreement becomes void. Third one is a voidable contract. According to section 2I, an agreement which is enforceable by law at a option of one or more of the parties but not at the option of the other is a voidable contract. Thus the voidable contract is valid and enforceable until it is repudiated by the party entitled to avoid it. Just like in a simple word, for a current situation, or for at a time of making contract, the contract seems valid, but in future one of the parties can claim that the contract is void. So at that time the contract becomes voidable. Just like, for example, if someone forcing me to do something, and for that contract again the other party is agreeing for doing that contract, but the force indicates about the voidable contract. The example states that Rohan sells me your house. One there are two person, Ram and Rohan, where Ram is forcing Rohan sell his house to Rohan, and if he doesn't sell, then Ram will kill Rohan. So that enforceability or forcing the contract is a voidable contract. Then unenforceable contract. It is a contract which is otherwise valid but cannot be enforced because of some technical defects like absence of proper stamps. Such contracts will not be enforced by the court until and unless the defect is rectified. For example, if we want to uh, if we have issued a promissory note, and for that promissory note we stick or we staple an under amount of sticker stamp, so the whole promissory note become a voidable contract. The example: a borrows rupees 10,000 from B and make a promissory note, and a 1 rupee stamp is to be posted on the promissory note. The agreement, though complete, is unenforceable because of the technical defects promissory note being understamped. So the actual amount of stamp should be stick there. The understamp amount should not be there. That's why it is called unforeseeable contract. The court or that contract will automatically becomes voidable. Then next one is a illegal contract. An illegal contract is destituted any legal effect from a very beginning. That we in a legal term we called it void ab initio. And illegal agreements are void agreements, and illegal contracts are also void contracts. There are no legal implication for illegal contracts. Just like a selling of drugs, medicines, which is not authorized by the medical person, and therefore he is selling that, it is called an illegal contract. Now based on enforceability, that is formal contract and informal contract. Formal contract is, the term is usually found in English law. Validity of this contract depends upon the firm. They are valid even if they lack consideration. These contracts are two types: contract under seal and contract of records. Contract under seal are in a writing and signed by the parties to them. Contract of record includes the court judgments and recognitions. Obligation in such case arise out of the judgment and not under the contract. If a judgment or if a court has ordered someone to do something, then that person should be able to or should have to do that activity. So if there is no consideration for that, but therefore that person should be doing that, that is called an formal contract. On the base of extent of performance, that is executive contract and executory contract. An executed contract is one where both the parties have performed their obligation. For example, A sells a TV set to B rupees 20,000, and B pays the price, and A hands over TV set to B. That is a simple valid contract. It's called an executory contract where both parties have performed their duties. A have to sell that TV to B, and B has to pay that amount to A. Both have performed their duties, so that will be an executed contract. Executory contract, where the contract is yet to be performed either wholly or partially, or one or both the parties have yet to perform their obligation. So the contract is said to be executory when one of the two parties have to perform the duty he has been assigned. That is called executory contract. When A is supposed to sell the TV and B is supposed to pay the amount for that TV, and A is giving the TV, but B is saying that I will pay the amount later on. So here in this contract, A is performing his duty. A has completed his performance, but B has not completed its performance yet. So that is called executory contract. So now based on obligation, that is unilateral contract, bilateral contract, and multilateral contract. Unilateral contract: in this, one party of the contract has fulfilled the commitment while the other party has yet to do so, just like a executory contract. Unilateral means only one party is performing his duty and other party is waiting to perform his duty. It's called unilateral contract, where one person is wholly involved in the activity or contract, and other person is not active right now, but in future he can be active or not. Then bilateral contract means both parties have done their duties. A contract in which both parties have fulfilled their commitments simultaneously. For example, A deliver goods to B and B makes the payment immediately. So we can take another example. When we went to shop, when we go to shop and we purchase something, and for that purchase we made payment to the shopkeeper, where we and shopkeeper both have performed their duty. It's called a bilateral contract. Now, multilateral contract, in this type of contract more than two parties are involved. These are very complex contract. For example, teacher and students of Global Pill High School and teacher and students of DAV School. Here we can also take another example of multilateral contract, like when we want to purchase a mobile phone, but we don't have that much amount. So bank is offering us to purchase that mobile phone on a EMI basis, where bank is making payment to the shopkeeper, and for that we will pay on installments to the bank. Here three parties are involved in this contract, where we are transacting for phone with a shopkeeper and for payment with a bank, and from us, on behalf of us, bank is making payment to the shopkeeper. So it is a type of multilateral contract. Then based on mode of creation, express contract, implied contract, and e-contract. E-contract, these contracts are entered into between the parties using internet. In electronic commerce, different parties person create networks which are linked to other networks through electronic data interchange. This help in doing business transaction using electronic modes. Like we are purchasing certain things from Amazon, Myntra, or Flipkart. It's just a type of e-contract. So here one person is purchasing a chocolate from Amazon. It's just like a type of e-contract. Thank you.